Hello, everyone. Welcome to Principles of Public Law, another lecture, another week. My name is Renato. For those of you who don't know me, I'll be lecturing you this week, and we'll be talking about the executive. Just wanted to show my face because a different voice will come up and maybe you wouldn't recognize it. So I just wanted to appear here on the screen really briefly. But let's move on to the lecture because we don't have a lot of time, and this is a really, really important topic. So allow me to move straight to the slides there. As I said, we'll be looking at the executive, and the focus I'm giving to you during this lecture is on the elements of the executive, the powers, and its conventions, or the constitutional conventions that are about it. As you probably know, the executive is one of the three branches of government. One of the three branches of the state, that is. Its primary role is to execute or administer the laws. So laws are produced by the legislature, they are judged by the judiciary, and they are executed, or its execution is administered by the executive. A modern definition of the executive will encompass the idea that the executive is to govern the state according to its laws, to execute the laws of the state, and to form policies by which the state is to be governed. This is what we mean by the role of administration of the state. This is why we also study administrative law, because it relates to this function. And this is sometimes, that is, the executive is also sometimes referred to as government itself, or the administration. We also refer to the executive sometimes as a body, the subject, or the government itself. And sometimes it's power. When we refer to the executive, we are actually making reference to the power the executive has the power to execute the laws. Of course, as you all know, I'm not saying that this is all that the executive does. There are other functions that the three branches can exercise outside of their regular or more prominent role. The executive, for example, can judge or even legislate in a sense. The judiciary and the legislative also have extra functions. As we have discussed in previous weeks, we saw how the legislature can actually not only legislate itself, but it also has some other functions. The same happens with the executive. Now, before we start with reading the Constitution, what the Constitution says, let's take a moment to think through the relevance of the executive. There you go. There are some scholars who defend that the executive is a massive, potent, strong branch, and I think they're right. It deals directly with the individual and the way the laws will be applied in our lives. We see the executive in action every day in a wide-ranging spectrum of situations. When you drive, for example, you need a license. When you're driving, you do not speed, otherwise you can get a fine. When you go to participate in a festival in South Bank, for example, you're probably going to experience a lot of good food, but also those people who are serving you the food, they need a permit, or you're going to park in a public parking area, or maybe even take the public transport there. You can receive parcels delivered to you via the Australia Post. You may be studying under scholarship given by the government here at UQ. You may also know someone who applied for unemployment benefit or programs like JobKeeper or Job Seeker, all of which are dependent upon the executive. I am actually here teaching you right now because I have a visa that allows me to work in Australia. As it was determined by a decision, and all of this relates to a decision made by a body within the executive. So I can only teach you because I have a visa that allows me to, because one person decided that I should be allowed to do that. And that decision comes from the executive. Actually, we were having this class because we cannot be in a room with more than 10 people right now, or we cannot fit all of the students of this class, of this course, in one lecture room. And this also is part of a decision made by the executive. What I'm trying to tell you or demonstrate is that, yes, the executive participates and is present in all of our lives, in many situations and in different levels. The executive participates and directs the life of individuals in a state. Some other scholars, however, they don't see the executive as that relevant of a branch. There is a famous quote from a Brazilian professor in administrative law that goes something like this. Allow me for the translation. He says, the executive's role is to administer, and to administrate is to apply the laws ex officio. Ex officio means as it is, without judgment or automatically. What he was saying was that the executive could not exercise in its essential function any valued judgment. There's no room for analysis other than what is prescribed by the law. This quote, although from, as I said, a Brazilian, expresses that French tradition of administrative law. The French tradition is the strongest tradition in the European continent regarding the role of the executive. It imbues the executive as a public service provider. Basically, in its origin, in its primary ideas, the executive government was related directly with providing individuals with public services. Later on, of course, it came to the knowledge of all that the executive had some other important roles that were not necessarily related to providing public services in itself, but predicated a more directive or managerial role in society. So look, what the Brazilian professor said was said in the context of a civil law country that has huge codes and an extensive legislation. But nonetheless, I think this case also stands and can be applied in our reality here in Australia. At least his arguments can be applicable to the Australian executive as well. What he was saying was that there are some boundaries to what the executive can do. So it's different from the previous scholars who see, as the image there shows you, that the executive is everywhere. What he's saying is that the executive can only do what the law allows it to do. That means that it limits itself in its administration and execution of the laws. So when he said that the executive is bound by the limits imposed in the statutes and the common law, he was actually limiting the scope of what the executive could do, to limit it to its proper function. Hopefully, you can see the big picture here regarding this debate. One side says the executive should be allowed to administer the state in its entirety, regulating specifically those areas that are hard or too technical or inaccessible somehow to the legislature. But the other side would contemplate the danger of giving too much room for the executive action. They would defend a government that is limited not only to the principles of law, but also to the specifics of the laws and statutes and common law here. The executive should not trump its limited role to apply the law in society. So there are two sides here. Now, I don't know what's your personal feeling about this, but it should be clear by now how the executive in its role represent the tensions that we usually see in public law as a whole. Do you see that? So remember the idea of constitutionalism? I usually refer to it as a struggle between empowering the state and constraining it at the same time. So it's about giving power, but also limiting the same power that was given. And to me, the executive represents that. Can you see that? That it's about giving power to the executive so that it can perform its functions and help society and direct society. But at the same time, we have to be aware of the dangers of giving too much power to the executive. Seems to me that when we talk about the executive, we discuss the same aspects as the ones we discuss when we talk about constitutionalism. How much power should the executive have in order to direct social life and the many societal spheres, and at the same time, what legal boundaries should be placed upon the executive so that it does not delve into tyranny. I'm not here to give you the answers to those questions, but to make you realize that the executive exists. It is important, it is relevant to our lives, and how we see it operating daily in our lives. It is very important for us to study it and understand its structures, conventions, and principles. So let's move to the Constitution. What does the Constitution say about the executive? Chapter 2 of the Constitution sets up the framework of the executive branch in Australia. In fact, Justice French of the High Court in 2001, he affirmed that Section 61, the one that shows up on your screen there, is the sole source of federal executive power in Australia. Let's take a look at it. By the way, I put the picture of the Queen there in the slide because she's the Queen of Australia, and Section 61, as we will read, vests the executive power in her, in the crown. And it says that the executive power belongs to the Queen. Let's read it. The executive power of the Commonwealth is vested in the Queen and is exercisable by the Governor-General as the Queen's representative, and extends to the execution and maintenance of this Constitution and of the laws of the Commonwealth. So there are some things that I think are important here. First, the Constitution refers to the executive power of the Commonwealth. It does not mention the states. I have said many times during my seminars that federalism pervades the whole structure of the Constitution. This is another example of it. The idea is that the states will have their own provision regarding the powers of their own executive. The executive power of the Commonwealth is limited to allow for the independent executive powers of the states. Second thing that I wanted to highlight. I've already said the executive is vested in the Queen and we know that it is exercisable by the Governor-General. So the Queen is the head of the Australian executive, or the Governor-General in practice, as we know. We believe in monarchy. We live in a monarchy. You can believe it or not. But the fact is that although we live in a monarchy, it looks like a republic. The Queen is the head of the executive, but it is exercised by the Governor-General, but as we will see later on, the Prime Minister and the government made up of ministers are the ones who actually have that role as the head of the executive. But look, constitutionally speaking, and according to the literal understanding of the Constitution, the head of the executive is the Queen. She is the formal repository of the executive power, with the Governor-General as her representative. Now, as I said, as we will see, pragmatically speaking, there's a different story, but the text of the Constitution gives that power to the Queen. The third feature that I want to tell you about is the fact that the Constitution says that the executive is vested in the Queen. It says is vested, not shall be vested. Why do you think that is? Think about it for a second. Normally, the idea of a constitution is to inaugurate a state, creating a state from scratch, right? But look at how the language here implies that the executive power already existed before the Constitution. It was not created necessarily by the Constitution, but it existed prior to it. It looks like a statement of fact. The power is vested in the Queen. The power that already exists is vested in the Queen. The reason why I think it is important to highlight this is because it makes sense for me to talk about reserved powers or the prerogatives of the Crown and other non-statutory powers that exist in the figure of the Crown, because the executive power already existed and belonged to the Queen. It had been developing over the years as part of the common law. There were powers that already existed that went beyond the execution and the maintenance of the Constitution and the laws of the Commonwealth. If the executive power, pay attention on this, if the executive power was created instantly from the Australian Constitution without making any reference to the previous powers that the Queen already had, then it would be really hard to apply the privileges and immunities of the Crown that already existed even before the Constitution came to being. So the expression there implies that all of those powers that existed under the common law, they would continue, and that executive power, all those powers are vested in the Queen and are exercisable by the Governor General. The fourth aspect that I want to highlight now is also in your slides there, is the expression that says extends to. The text says that the executive power extends to the execution and maintenance of the Constitution and the execution and maintenance of the laws of the Commonwealth. It does not go beyond that expression. It just says that it extends to those things. There's no other direct reference to what the executive can do. But it does imply that there are other powers beyond the execution and maintenance of the Constitution and the laws of the Commonwealth that can be exercised by the executive. It does not limit it, but it does imply that the executive has authority over other matters. This is not to say that the Constitution did not exemplify some of the other powers. There are constitutional powers that give that give specific powers to the Governor General and as the Queen's representative. We've looked at some of those during week 4, when we learned that the Queen and the Governor General are elements of Commonwealth Parliament. We saw some of those powers, especially in Section 5 of the Constitution. But there are also expressed powers that are given by the Constitution to the Queen and her representative. I've listed here some of the powers you can see on the screen. They include summoning, proroguing, and dissolving Parliament, giving assent to bills. This we've already looked at, but pay attention in the extension of powers that relate more to the primary function of the executive. Appoint ministers of state, establish departments of state, appoint civil servants, command naval and military forces, or even, skip to section 72 there in the list, to submit proposed constitutional alterations to referendum. And there are, of course, other functions that also relate to the executive power, but in its interactions with the other branches, such as Section 72, regarding the appointment of justices of the High Court and the other federal courts. We now understand that ample scope of the executive power, how its primary function is to administer the state and execute the laws, and how, according to the literality of the Constitution, it extends to the execution and maintenance of the Constitution and the laws of the Commonwealth. In fact, the framers of the Constitution chose to leave Section 61 as it is, without defining the powers of the executive, thus allowing for the system of representative government to develop itself. That is, allow for the relationship between the legislature and the executive to be ruled by conventions. So, are there any other types of executive power? If yes, then what are they? Let's take a look. First, I have identified the constitutional powers. These are expressed in the text of the Constitution. They flow from Section 61 and can be perceived in other sections as well. Section 62, 64, 67, 68, for example, Chapter 2 of the Constitution as a whole. But there are some other powers that are, as I said before, implications from Section 61. They derive from that idea of extends to that we referred previously. One example is the statutory powers that can be given to the executive. These are powers that are given to the executive by Parliament via the enactment of legislation. The most familiar executive functions are included here. They usually relate to social security matters, policing, taxation, elections, immigration. These are some examples I'm giving you. So it is very common to have laws giving powers to the executive to issue certain licenses, to drive, to build, to operate as a business, etc. They all are direct implications of specific statutes that were enacted by Parliament, thus giving statutory powers to the executive to administer the state. The widest statutory power given to the executive are deemed to be those ones given to the Australian Defence Forces. I assume you can understand why. Especially those powers given by the Defence Act of 1903. It exemplifies one important feature of statutory powers, that is discretion. The idea of discretion is not novel. Sorry. John Locke had referred to it. Sometimes it is called the metaphysical quality of the executive. Because what it implies is that although it is beneficial to have Parliament discussing the provisions and the capacities that will be given to the executive, Parliament cannot prescribe or foresee all accidents and all necessities that society encounters. As representatives of the will of the people, Parliament manages to give certain powers to the executive with one hand and limit those same powers with the other. That is, overall, very good. That's the purpose of Parliament as well. But there are some situations in which Parliament cannot say for sure what will happen. They cannot foresee everything that will happen in society. What exactly will flow from the determinations they have given in the statute is hard to predict. In light of that, there's a need to fill that gap, where the public servant has to choose between two legal alternatives within the realm of legality, but different alternatives and options. Without detailed criteria expressed in the legislation, there's the need to have a person making a call, a judgment call, and that has to be immediate as the situation unravels. This call or decision that is made within the bounds of legality, but as a result of the lack of criteria expressed in the law, is what we call discretion or discretionary powers. The executive, usually within its statutory powers, has the discretion, the choice, the option regarding the way in which they will effectuate their decisions and acts. I have put also delegated legislation as one of the subtopics in the statutory powers, because the executive can only legislate and create proper statutes if Parliament authorizes it. The source or head of power still belongs to, in that situation, still belongs to Parliament, and it can revoke its delegation as it wills. So Parliament has not only given within the realm of statutory powers to the executive, but also it can delegate the power itself to make laws to the executive. So technically, when we refer to the delegated legislation that the executive can make, we must remember that a delegation does not erase the supremacy of the one who had the authority to provide for the delegation in the first place. That is, Parliament still has the ultimate authority over the executive regarding the powers to make laws. But in the exercise of its delegated authority, the executive can create the laws as they wish, limited, of course, by the scope of the delegation itself. This happens because it is hard for Parliament to legislate specifically about everything. Not only Parliament cannot predict everything, and therefore there are discretionary powers, but also Parliament cannot legislate specifically about everything. Think of a very technical sanitary rule or an engineering practice in the industry, or rules regarding urban or cities or architectural techniques and rules that should be complied with and must be enforced for the common good, Parliament probably does not have the expertise to create a norm that is so specific. They don't know about it. They need help from people who actually understand the technical aspects of that legislation. That's why Parliament can ask the executive to legislate on their behalf. Because the executive has public servants, civil servants, they have more capillarity. So it's easier for the executive to legislate about certain issues because they have people who understand about those topics. So these enactments, so to speak, coming from the executive, they're usually called regulations, rules, or ordinances, or bylaws as well. But of course, as I said, Parliament can revoke the delegation, assuming once again the power to legislate about the topics that were first delegated to the executive. But the executive has not only those prescribed expressed powers, some of its powers are not entrenched either in the constitutional text or in the statutes made by Parliament. These are what we call non-statutory powers. Among them, we have the reserve powers, the prerogatives of the prerogative powers, the common law capacities, and the nationhood powers. I will briefly introduce them, and I'll let your seminar leaders discuss them further with you. And you probably have questions about that during the week. So first, let's start with the idea of reserve powers. Reserve powers are those powers given to the Governor General when, in special circumstances, he or she will not act on the advice of government. Remember that we talked about the role of the Governor General as basically just doing whatever it's the will of the government. So acting, that is acting on advice of the Prime Minister or of the ministers. Well, when the Governor General acts according to his or her own discretion, then that's when we see the operation of the reserve powers. These powers include powers to appoint and dismiss a prime minister, to refuse to dissolve parliament, or to force its dissolution, and to ensure that the government is acting legally. Remember, these are all exceptions to the rule that Governor General must act on advice. The most famous and so far amply discussed use of these powers happened in 1975 during what we call the constitutional crisis, when the Governor General dismissed the Whitlam's government and called for new general elections, despite the Prime Minister having the majority in the lower house. So you see how the Governor General of the time acted on his own behalf without following the advice of the Prime Minister. The other type of non-statutory executive power is called prerogative powers. The prerogative powers are historically those given to the Crown in exclusivity, meaning they relate to the powers, capacities, and immunities that the Crown, the Queen, or the King has enjoyed under the common law. Some of them can be seen in the declaration of war or peace, granting of pardons, immunity from prosecution, or the rights over precious metals and treasure. The common law capacities or the common law capacities of the Crown are kinds of prerogatives in the sense that they are non-statutory powers that belong to the Crown in its function as the executive. But the difference here is that the capacities of the Crown, the common law capacities, are powers that others also share. So while prerogatives are exclusive of the Crown, the capacities, they encompass powers that the Queen's subjects also have. These capacities allow the executive to enter into contracts, to create companies, buy and sell properties, sue and be sued, etc. So they are the common law capacities because they are enjoyed not exclusively by the Crown, but also by individuals. And the other kind of non-statutory powers that we can see there in the slides is the nationhood power. Although it sometimes looks like an implication of the prerogative powers, those exclusive powers that the common law has historically given to the Crown, these ones here relate, as the name indicates, to powers regarding the nation. It's about the national interest, the sovereignty of the state, the identity of the nation as a whole. So they regard powers to create flag, to protect the symbols of the nation, to have a national anthem, but also to protect the land because of its sovereignty from invasion, or to extradite or expel aliens. So these are all developments of this idea of nationhood powers. So although they do relate to the authority of the Crown over its subjects, and it is obvious that the individuals do not have the power to determine anything related to those symbols or historical dates, these are distinct from the prerogative powers because they have the national interest rubric over it. It is hard to define the precise limits of this power, but it is helpful to appreciate that they relate to a more national interest understanding of society. Well, what are then the limits of all these powers, especially the ones that are non-statutory? How can we give non-statutory powers to the executive and still limit it? How can we restrain it when the executive does have some powers that are not limited by the laws? The first and foremost principle of limiting power is the rule of law. Now, I'm not going to spend a lot of time here because you're doing an assignment about it, and by now you've done a lot of research and you probably know about the rule of law more than I do. But allow me just to read how this principle of the rule of law has been applied conventionally in Australia and in relation to the executive. You can find there in the part of the slide the oath made by Queen Elizabeth II during her coronation. Look at what she says. I highlighted some of the parts. I think you can see that in bold. The Archbishop of Canterbury asked if she would promise to govern the people of Australia according to their respective laws and customs. And she solemnly swore to do so. She promised to do so. What are the implications of that oath? Well, that means, in a nutshell, that the Queen will not override the decisions made by Parliament, and she will comply with the constitutional conventions that are present in Australia. So ultimately, we have a Queen, I mean, you have a Queen, because I'm not an Australian subject, I'm not a citizen here, so you have a Queen that will uphold the customs, the conventions that are made here. Some of these conventions will move towards, we will move towards them now. They actually reduce the power and the influence of the Queen in Australia. And that is fine. But the fact that the Queen respects them should indicate that the executive as a whole must, of necessity, respect them as well. There's a clear limitation in that oath to the executive power. The executive must not and cannot go over the Constitution and the common law. The rule of law exists and the executive must never abrogate it. One of the constitutional conventions that we have here in Australia related to the executive is the principle of responsible government. I want to focus on that maybe for the rest of the lecture. I want to talk about its concept, its structure, and its implications. So let's move forward here. According to Quick and Guerin, Section 61 recognizes the principle of responsible government, meaning that the discretionary powers of the Crown are exercised by the wearer of the Crown or by its representative, the Governor-General, according to advice of ministers that have the confidence of the branch of the legislature, which immediately represents the people. Responsible government, together with representative government, federalism, and the separation of powers, is one of the most important constitutional principles. It dictates that power be exercised by ministers, themselves members of parliament, who are responsible to Parliament and ultimately to the electorate, and whose confidence is a prerequisite to their exercise of ministerial power. So once again, let me repeat this. Responsible government demands that the executive be acting on advice of ministers who are members of Parliament and therefore responsible, accountable to Parliament. That's why Quick and Guerin continue and say, see the slide there, the practical result is that the executive power is placed in the hands of a parliamentary committee called the Cabinet. And the real head of the executive is not the Queen, but the chairman of the Cabinet, the Prime Minister. Look, the principle of responsible government is part of the whole texture of the Constitution. It is there in the structure. It's in its meaning. It is one of the pillars of the Constitution. As Justice Isaacs said in 1922, you can see it there, although invisible, responsible government is such a part of the Constitution that any disregard to it would make a false and misleading interpretation of the Constitution. This is basically what he's saying there. It is not to say that everyone agrees to the exact extent of the principle, as you can see in the quote below that of Justice Isaacs. But it is indispensable to the understanding of the Australian Constitution to appreciate that. Pay attention to what I'm about to say here. The executive power is formally vested in the Queen and exercised by her representative, the Governor-General. But in practice, there are limits to those powers under the rule of law, and these limits that were agreed upon by the Crown. There's a need for the existence of ministerial responsibility. That is, the Governor-General will act on advice of ministers who are themselves members of Parliament and thus responsible to that Parliament and ultimately to the electorate. This is the gist. This is the idea of responsible government. With that in mind, then let's take a look at the actual structure of the executive. This time, paying attention not only to what the Constitution says, but to the principle of responsible government. It looks quite different from the literality of the Constitution, doesn't it? Sitting at the head of the executive, we do not see the Queen, or even the Governor-General for that matter, but the Prime Minister. The Prime Minister is the leader of the party that enjoys the majority in the House of Representatives. And he or she will be the head of the government, that is, the head of the executive. Hey, did you know that not so long ago there was a research that asked who was Australia's first Prime Minister, and more than 70% of the people did not even know the answer? Do you remember? Do you know the answer? Yeah, of course you do. You're from UQ. I mean, if you were from another university, maybe you didn't know, but UQ students do know that, and you're right. You know it was Edmund Barton, and that he resigned in 1903 to become a member of the High Court. But anyways, the other element that responsible government has added to that executive structure is the Cabinet. It's the second one that I put there on the conventions. The Cabinet is formed by the most senior ministers, or the ones with the most important portfolios. So Treasury, Foreign Affairs, Defense, the Attorney General. And since the Whitlam Labour government of 1972, it is a practice that the ministry be divided between the Cabinet and the outer ministry with the other ministers. So we have the Governor-General as a representative of the Queen acting on advice of the Prime Minister, who decided in this council, who decides in this council called the Cabinet, where he discusses the main matters with the senior ministers or those with the most important departments portfolio. There are nonetheless other important ministers who can participate in the Federal Executive Council, so sections 62 and 63 talk about it, and they administer some other departments that exist within the machinery of the executive. These elements, all of them, form what we call the government. So the government is the prime minister, and its ministers, they are appointed by the governor general after they have the confidence of the lower house of parliament. The constitution also mentions the departments of the state, of state, but it is true that there are some other bodies that help the ministers and the executive government in their activities as well. So that is in administering the state. So a couple of examples are the statutory agencies and the government-controlled corporations. Let me list a few of those to provide you with some practical examples. So we have the Department of Education, Skills and Employment, then the Department of Home Affairs. These are obviously examples of departments as prescribed by the Constitution. There are 14 departments at the Commonwealth level today. There are numerous statutory agencies, and they relate to a wide variety of areas. Like I've researched this a little bit, and I found the Asbestos Safety and Eradication Agency, the Australian Human Rights Commission, Law Reform Commission, Cancer Australia, Great Barrier Reef Marine Park Authority, and the National Library of Australia. These are all famous ones. And to give you a further example, we have, of course, I think these ones are more famous than the other ones. The Electoral Commission, the Australian Bureau of Statistics, the Office of National Intelligence. So do you see how the executive is everywhere? Can you see that? It relates to everything. All matters are under it. Okay. There are also the government-controlled corporations, so state-owned companies like the ABC, the Australian Broadcast Corporation, the Australia Post, and the NBN Corporation. So great internet for you. And of course, these agencies and corporations and departments do not work wouldn't work if they didn't have civil servants or public servants who work at the departments and the agencies. So, a fast recap here. We have the legal form. The constitutional provisions place the exercise of executive powers primarily in the Governor General. So, it's appointed by the Queen. He or she will appoint ministers of the Crown, establish departments of state. They will administer government department, and those ministers will administer the government departments, etc. But there's also on the other side the political practice, the procedures according to the constitutional conventions. So the Governor General acts only on advice and depends on the ministers of state to administer the laws and execute them and maintain and to execute and maintain the Constitution and the Commonwealth laws. So hopefully you can take a look at it later on, but there's also the conventions that enforce new aspects to what the Constitution actually says. And there are some conventions that come with the principle of responsible government. We have looked at the meaning of the concept, and you can notice that it relates intimately with the minister, that is, with the idea of ministry and its relationship to parliament, because I always said that it relates to how the minister, they are accountable to parliament, and how the executive, the head of the executive, the prime minister, will advise the governor general so he or she can make a decision. So it all revolves around the ministers. There are two main areas of responsibility within the concept of responsible government. So the individual responsibility and the collective responsibility. The first one dictates that the actions and omissions of the department are attributed to its minister. The minister is the head of the department. Therefore, any failings concerning waste, negligence, or corruption will fall under the responsibility of the minister. This will also be true if the failings are personal. The minister cannot, for example, mislead parliament or act corruptly. It is part of the individual responsibility of the minister to inform about the actions and decisions of his or her department and portfolio, as well as to explain any issues or doubts that may be raised by the other ministers. The moment we would normally see this happening is question time. And we talked about question time a couple of weeks ago. That is the best example of when individual ministers are put on the spot and held accountable for the things that are happening in their departments. It is crucial for the principle of responsible government to have the executive under scrutiny in Parliament. Holding the minister into account is the way to ensure that the government stays accountable. If a minister fails to be responsible for its department, or if mistakes happen, he or she should apologize and they should seek to remedy the situation. Or if the circumstances dictate it, he or she must resign. Let me give you an example. This is a good example. This issue involved Mr. Barry O'Farrell, who was elected as the Premier of New South Wales. According to the findings of an independent commission against corruption, Mr. O'Farrell received, listen to this, a 3,000 bottle of wine from the head of a certain company. So this was due to his election. So as congratulating him because of his election, he received a $3,000 bottle of wine. And the thing was that this was in 2011, the election. The problem was that he denied that he had received the wine and that he had thanked for it. But the owner of the company, his name was Di Girolamo, he told the commission that he received a call from Mr. O'Farrell, the Premier of New South Wales, thanking him for the wine. And despite there was a phone call, there were some phone records of that call, Mr. O'Farrell, he denied ever receiving the wine or making the call to thank the company owner. So later on in a statement, Mr. O'Farrell came to actually admit that he didn't know that he received the wine, that he doesn't remember the call, but that seemed to exist a note, a thank you note signed by him about talking about the wine. So he actually went before the commission and he said, and I'll quote him here, he said, "I've been advised overnight that this morning at a thank you note from me in relation to the bottle of wine will be presented to the commission. I still cannot recall the receipt of a gift of a bottle of wine of 1959 Grange. I can't explain what happened to that bottle of wine, but I do accept that there is a thank you note signed by me, and as someone who believes in accountability, in responsibility, I accept the consequences of my action. The evidence I gave to the Independent Commission Against Corruption yesterday was evidence to the best of my knowledge. I believe it to be truthful, and as I said before, it is important that citizens deal with police, deal with the courts, and deal with the watchdogs like the Commission Against Corruption in a truthful fashion. In no way did I seek to mislead, willfully or otherwise, the Independent Commission Against Corruption. But this has clearly been a significant memory fail on my part. Although within weeks of coming to office, but I accept the consequences of my actions. And that is that as soon as I can organize a meeting of the Liberal Party for next week, I will be resigning from the position and enabling a new Liberal leader to be elected, someone who will then become the Premier of New South Wales. So I think there are two lessons here in that story. One, that if the minister, an MP, and an elected member of parliament fails personally, he or she must resign. It's imperative for the structure, for the meaning of responsible government. It is part of the system prescribed in the Constitution to do so. If the member of parliament fails to resign, he or she may be bringing down the whole government with them. So to avoid that, they should resign. The second thing that comes to my mind is that if you ever want to give a gift to me or to any of your public law lecturers, please don't forget that it's always available to give $3,000 bottle of wine for us. So it's a great gift idea, and I would appreciate that very much. Okay, so that brings us to collective responsibility. What this facet of the principle of responsible government enforces is that government must have the confidence of the House of Representatives. If they lose that confidence, the opposition will take its place and will become the government of the day. There are two main ways of assessing that loss of confidence. The first, by a vote of no confidence from the House of Representatives. This will typically occur when the majority of the seats in that house are lost. But the other way is by not guaranteeing supply. If a money bill is not approved, the government will run dry of money, it won't have money, and it will be unable to operate and execute the laws as their primary function. So in that scenario, the Prime Minister and the government should resign. So remember the facts of 1975, the constitutional crisis, and how the lack of supply, the approval of supply bill by the Senate brought down the Whitlam government. So without the confidence of the House, the government must resign in its entirety. The two other conventions of principle of responsible government relate more specifically to the cabinet. One is called cabinet solidarity, because the decisions made by the cabinet are to be unanimous. The minister therefore must vote in favor of the government measures and support always what the cabinet decides. Cabinet is like a unity. It represents the decision-making body of government. So ministers cannot undermine it by being part of it and then vote against it. So they must always support the decisions of the cabinet. This is what we call cabinet solidarity. But look, of course, ministers can discuss widely and openly during the cabinet meetings. They can disagree with one another, and while cabinet is in session within council, they can deliberate and disagree and give their opinions and etc. And that's fine. But once the decision is made, it must be unanimous. Therefore, cabinet meetings are secret. There is a secrecy. And this is what we call cabinet secrecy or cabinet confidentiality. The documents, the opinions, and the discussions that happen within within the cabinet will stay in the cabinet. It's kind of like going to Las Vegas. What happens there stays there, okay? So finally, I'm coming to the end of my lecture. I just wanted to show you some direct implications from the constitutional text that reveal the existence of this responsible government. And this will help us understand some cases that will be discussed during the week in our seminars. They relate to the way that the government can spend money as one of its capacities, so one of its powers. Section 64 and 44 affirm that minister must hold their seat in parliament, despite the fact that section 44 does not allow for a member of parliament to hold offices of profit under the crown. And we looked at that at this last week. It is understandable that the office of minister does not count in terms of section 44, that is profitable office under the crown. But ministers must be members of parliament to answer questions during question time and to demonstrate the operation of their departments. Another way in which we see the principle of responsible government in the limitation placed on the executive to raise is in the limitation placed by the executive to raise revenue without the approval of parliament. So look, this comes from the Bill of Rights, but it's also present in section 51(2) of the Australian Constitution. This leads to the understanding of sections 81 and 83, which demand the Commonwealth government to put its revenue in one consolidated fund to be appropriated for the Commonwealth purposes. However, the Treasury cannot appropriate money without an authorization made by law. So government needs Parliament to spend money. Ultimately, that's what happens. government still needs Parliament to spend their money. The way this dynamic is enforced will be looked at in our seminars and is narrated in chapter 7 of your textbook that I know all of you have read. I hope you enjoyed our lecture. It was a pleasure for me to be here with you today. If you have any questions, please talk to your seminar teachers or talk to me. That's my email there in the slide, so you can contact me. And I hope to see you next time. Have a great day. Bye.